Hello everyone, and thanks for joining us today at the Firearm Firm channel. Today we're going to be talking about a question we frequently get at my firm that I wish a judge here in Florida would have called and asked in before he accepted and sentenced a man in Charlotte County, Florida. The question is, do I have to give up my guns if I live with a convicted felon? So what prompted this video was a news article I read earlier this week titled, "Judge, You Have a Choice, Your Husband or Your Guns," written by the gun writer Lee Williams. In this article, Mr. Williams discusses what happened to Lisa Maroc when she was in court with her husband Ralph Maroc, who was there to enter a negotiated plea and be sentenced for shooting into a vehicle or dwelling, which is a second-degree felony in Florida, and a second charge of criminal mischief, which is a misdemeanor charge. Pursuant to a negotiated plea agreement, Mr. Maroc was to receive 10 years of probation, which could be terminated early if he completed all the special conditions and had 0 violations. While Mr. Maroc was in the process of entering his plea, Circuit Court Judge Shannon McPhee called Mrs. Maroc up to the podium beside her husband and then placed her under oath. Judge McPhee told Mrs. Maroc that she couldn't ever own a gun again in her life. He then told her that she had a choice, your husband or your guns. The judge went on to explain to her that she could have no guns in her house or even carry one for protection. Now, keep in mind, she has nothing to do with the case against her husband. She was a law-abiding citizen and possesses a CWFL. Judge McPhee refused to be interviewed by Mr. Williams for this story, but did submit a written statement through his spokesperson. In his statement, Judge McPhee wrote, Mr. Ralph Maroc accepted a plea to the charge of shooting at or within a dwelling, a second-degree felony in the state of Florida. Additionally, this plea calls for Mr. Maroc to be registered as a convicted felon. The Assistant State Attorney clearly announced the plea deal to Mr. Maroc that included no longer being allowed to lawfully possess a firearm or ammunition or a concealed weapon or the ability to vote, etc. These implications were discussed with Mr. Maroc, and he voluntarily agreed to these terms with his plea, which is a downward departure based upon the plea bargain between counsel. Mr. Maroc scores out 19.5 months prison. Instead, Mr. Maroc received at least 5 years state probation. The court became aware that Mrs. Maroc had a concealed weapons permit and may have weapons stored in the home, which would subject Mr. Maroc to a violation of probation and potentially going to prison. Judge McPhee was taking the necessary time to ensure that Mrs. Maroc understood the terms of the attorney's negotiated plea, and if she was in objection, then the court would not accept this plea. Mrs. Maroc was in agreement with the plea deal and pledged not to have any weapons in the home being shared with Mr. Maroc, a convicted felon. This totally is mind-blowing to me. This judge has absolutely no authority to make Mrs. Maroc, in essence, relinquish her constitutional right to bear arms. Absolutely no authority. Now, the judge is correct that Mr. Maroc cannot possess firearm or ammunition, but just because he can't doesn't mean she can't. So, going back to the initial question at hand, does a person who is legally allowed to possess firearms have to get rid of their firearms if they are residing with a convicted felon or someone who is considered a prohibited person under state or federal law? The answer is no. However, that person will need to take some additional steps to ensure that the convicted felon or prohibited person is not considered in possession of their firearms. There are 2 ways a person can be found to be in possession of a firearm or ammunition. The first way is actual possession. That is when the individual has the firearm on his or her person. So if Mr. Maroc had one of Mrs. Maroc's firearm in his waistband, he would be in actual possession of that firearm and in big trouble. The other way a person can be determined to be in possession of a firearm is known as constructive possession. This occurs when the firearm is not on the person but is in a location that is under their control and he or she has knowledge of the firearm. An example would be driving your car knowing that you have a gun under the driver's seat. There are 2 key components when it comes to constructive possession: knowledge and control. So an example would be if you borrow your friend's car and he did not tell you that there was a gun under the driver's seat, you are not in constructive possession of that gun, even though you are exercising control over it by being in such close proximity of it, in essence sitting on it. And you wouldn't be because you did not have knowledge that the gun was there in the first place. Likewise, you would not be in constructive possession of a firearm if you were sitting in the passenger seat of your friend's car while he was driving, knowing that your friend has a gun under his seat. Why? Because you are not exercising any control over that gun, your friend is. So going back to Mrs. Maroc's situation, She absolutely has nothing prohibiting her under federal or state law from having a gun on her person or in her home. The only person who has restrictions is her husband, because he is now a convicted felon and is prohibited from possessing firearms and ammunition under federal and Florida state law. To keep Mr. Maroc from violating the law, Mrs. Maroc does need to make sure that he cannot be in actual or constructive control of her firearms. When they're in their home, this can be done by storing the firearms in a locked safe in which Mr. Maroc has no access to. In other words, Mr. Maroc cannot know the combination or have a key to open the safe. Although he knows in that situation that there are guns in the safe, because he is not exercising any control over them because he can't open the safe, he would not be in constructive possession of them. Would Mrs. Maroc be able to walk into her house with the gun on her person or in her purse if Mr. Maroc was home? Yeah, as long as she was the only one exercising control over the gun. What she could not do is take the gun out of her waistband or out of her purse and set it on the kitchen counter where Mr. Maroc could exercise control over it. What if they were riding in the car together? She can absolutely have a gun on her person or in the car under her car seat. She can have it anywhere in the vehicle where Mr. Maroc has no ability to exercise any kind of control over. What she could not do is, if she was driving the car and Mr. Maroc was a passenger of the car, she could not take her gun out of her waistband and put it in the center console between her and Mr. Maroc, or in the glove box directly in front of Mr. Maroc, who is sitting in the passenger seat. Now, when it comes to constructive possession, that is how most people who are convicted felon or prohibited from possessing firearms get in trouble. They know that they can't actually have it on their person, although some people still get in trouble and carry firearms on their person, but most of the time it's an accidental constructive possession case. Constructive possession is very confusing. So if you live with someone that is a convicted felon or is prohibited from possessing firearms or ammunition, you're probably going to have questions about what you need to do to make sure that other person doesn't get in trouble. On top of things, I will tell you that I have personally seen law enforcement become very creative in trying to allege someone who is not supposed to have a firearm to be in constructive possession of it. So, if you are living with someone or are going to be around someone that is a convicted felon or is prohibited from possessing a firearm or ammunition under federal or state law, give us a call if you got questions. You can reach us at 321-332-6864. You can also email any questions you may have about that situation to us directly at questions@thefirearmfirm.com. Finally, be sure to let us know what you think about this judge's actions. Do they upset you as much as they upset us? Do you think he was right in doing what he did? I don't know. Be sure to tell us by leaving them down in the comments section below. Also, if you enjoyed this video, be sure to hit the like button, and if you haven't already done so, be sure to subscribe to The Firearm Firm by clicking on that subscribe icon down in the bottom right-hand corner of this video. Until next time, stay armed and educated.